Good morning. Happy hump day. Pennsylvania versus Mims and Maryland v. Wilson are two Supreme Court cases that definitively and decisively settled the issue of whether or not the cops can get you out of a vehicle if they've lawfully stopped it. Now, it's not up to you to determine whether or not you've been lawfully stopped. It's never up to you, not even if you're a judge. Judges don't get to determine if they have been lawfully stopped. A judge would be precluded from presiding over any case where the question of whether or not the judge had been lawfully stopped was at issue. So the person who is getting stopped never, ever, under any circumstance, gets to determine whether or not they've been lawfully stopped. That's a question for the court at a later date. Now, if you have been lawfully stopped, the police can, under Pennsylvania versus Mims or under Maryland versus Wilson, depending on whether you're the driver or a passenger, they can get you out of the vehicle. They can order you out of the vehicle, and they can force you out of the vehicle if you don't comply with their orders. We've seen countless videos of sovereign citizens having their windows busted out because they would refuse to get out of the car. The police can and will get you out of the vehicle if they've ordered you out of the vehicle. And maybe I should back that up, because they can get you out of the vehicle. Now, will they? Sometimes you might be able to talk them out of getting you out of the vehicle, but I'm going to say that would be the exception and not the rule. The rule is they'll get you out of the vehicle. Now, it doesn't matter under Pennsylvania versus Mims and Maryland versus Wilson whether or not the police think that you're armed. That was not a consideration in either of those cases as to whether or not they can get you out of the vehicle. In Pennsylvania versus Mims, there were two issues presented. Number one, could the police officer order Mims out of the vehicle? The police officer had no reasonable articulable suspicion at the time when Mims was in the vehicle that Mims was armed. So the first question the court had to resolve was, did the officer have the authority to get Mims out of the vehicle? And the court said yes. The officer was entitled to order Mims out of the vehicle. Mims is detained. They have various reasons for it, including officer safety, generally speaking, officer safety. And they can get him out of the vehicle. Now, the court in Maryland versus Wilson clarified that is just a matter of course. The officer can, as a matter of course, order the driver or a passenger out of the vehicle. As a matter of course. He doesn't have to have some calculation. He's not going to have to prove that there was some issue of officer safety later in court. Just as a matter of course. The question the court's going to ask is, was the stop lawful? Did the officer order you out of the vehicle? Did you comply? That's it. I mean, it really depends on what the actual issue is. If it's a suppression issue, then you're only dealing with the first of those two things. If you're suing the officer for property damage or using force on you to get you out of the vehicle, there would be the third one. Did you comply? No? Well, then the officer has the authorization under the statutes and laws of your state, check with the local attorney, to get you out of the vehicle using force. I mean, that's why cops carry guns and tasers and nightsticks and mace and handcuffs. It's because they are authorized to use force against people in certain circumstances. And getting you out of a vehicle is one of those circumstances where they can use force, and they do. So the first issue in Pennsylvania versus, so the entire issue in Pennsylvania versus Mims was Mims had a firearm on him. He was unlawfully carrying a firearm, and he wanted that suppressed. So he made two arguments to suppress the firearm. Number one, he shouldn't have been ordered out of the vehicle. that was an unreasonable search or seizure under the Fourth Amendment. The court said no, it was not. The officer can force you out of the vehicle. He can order you out of the vehicle. If the officer couldn't have ordered him out of the vehicle, then the officer, after he ordered Mims out of the vehicle, seeing the bulge in the jacket pocket, that would have been suppressed, fruit of the poisonous tree. But because the officer could order him out of the vehicle, then him seeing the bulge in the jacket when Mims got out, then that was fine for reasonable suspicion that Mims was carrying a firearm in that pocket, thus the Terry frisk, thus finding the firearm, thus the firearm charge. So the second question in Mims was the frisk, the Terry frisk, reasonable? And yes, once the officer had him out of the vehicle lawfully, the Terry frisk was fine because the officer had reasonable, articulable suspicion that Mims was carrying the firearm unlawfully. So if a 20-year constitutional law scholar is telling you that you don't have to get out of the vehicle, take a few minutes and watch some sovereign citizen videos where the windows get broken and the officers pull them out of the vehicles. If officers weren't able to do that, if they weren't authorized to do that, there wouldn't be so many of those videos. Officers can get you out of the vehicle. Now, if this 20-year law scholar, this 20-year constitutional law scholar who doesn't understand Pennsylvania versus Mims and Maryland versus Wilson, if he's telling you that all you have to do is show your waistband, well, that doesn't show the officer. Well, first of all, it doesn't address that the officer can get you out of the vehicle as a matter of course, i.e., for any reason or no reason at all. Just, I stopped you, that means I can get you out of the vehicle as a matter of course. But it also does nothing. I mean, even if you buy into the line of reasoning that if you're unarmed, then you're not a danger, and therefore the cop has no grounds to pull you out of the vehicle. Even if you buy that, assuming arguendo that that's correct, and it's not, but even assuming it's correct, riddle me this, Batman. If you're showing your waist, how are you going to show that you're not sitting on a firearm or some other weapon? How are you going to show that there's not one in the small of your back? How are you going to show that there's not one under your seat or between your seat and the console or in the console or in the glove box or anywhere else in your vehicle that the cop can't see and you can't show him readily? Are you going to allow the cop to search your entire vehicle before getting out of the car? And here's a stupid question. If you're not carrying a firearm, why does it bother you to get out of your vehicle? I mean, if it's raining, you're like, gee, officer, it's raining. I don't want to get out of the vehicle. Can I just sit here? Or if it's cold out, if you have some reason like that, maybe the cop will do it. I have heard traffic stops go that way. But if it's just, I'm not armed, officer, you have to let me stay here, well, you're challenging the cop, and he's going to wonder why you won't get out. And you're going to escalate the situation. And for the love of God, it did not help Chili when he was arrested this last time. All of his alleged constitutional law knowledge did not help him. That's the last thing I kind of want to address in this video before it gets too long. Cops don't have to know case law. They don't have to know case law. Cops aren't lawyers. Cops aren't judges. Cops are cops. Cops are there to follow basic rules, basic understanding, and arrest you if you have committed what they perceive to be a violation of law. That's it. That's all they have to do. They're there to enforce the laws. And they don't interpret them. They don't argue them. They enforce them. It's in the name. law enforcement. They enforce it. They don't interpret it. They don't make decisions on it. They don't create the laws. None of that. They just enforce the laws. They have a basic understanding of the law. They don't have to know cases. They have someone come in and tell them, okay, this is procedure. Someone who understands the law, who understands the cases, is going to say, okay, based on these cases, we need these policies to make sure that our officers aren't in violation of known case precedent, known statutory legislation, things like that. So these are the policies. So cops operate on a policy level. These are the procedures we go through. I get to tell you to get out of the car. Well, Pennsylvania versus Mims says you, or whatever, says you can't tell me, blah, blah, blah. No, the cop says the policy is I get to get you out of the car. So I'm going to do that. Arguing with the cop is wasting your time. Your time, the cop's time. Chili, when he was running around trying to not get arrested, trying to cite the 2015 case of Gonzalez versus the U.S., or whatever he was citing. I don't remember what case it was at this point, but he was, you dunce cap, there's a case on this, blah, blah, blah. You can't extend the stop. The cop was like, watch me. And he arrested him. Like, that's it. The cop doesn't have to know cases. He's got a gun. He's got a taser. He's got a nightstick. He's got handcuffs. He's got the ability to use force. That's all he needs. It's like arguing case law with a dog or a bear or any other animal. They don't care. They don't care. You're not going to convince a cop he's wrong. That's why this trifold nonsense is such nonsense. You don't argue case law on the side of the road, especially not if it's a trifold created by someone who hasn't even gone to college, let alone law school. For fuck's sake. So, long story short, if a cop orders you to get out of the car, you have a decision to make. You can get out of the car, take that minor inconvenience, or you can resist. It doesn't matter how you resist. You can just say no. You can cite case law. You can lock your door, whatever. But whatever you're doing, it's resisting the order of the cop, in layman's terms. And the cop can, and very well may, use force to force you out of the car. And you get to make that decision. As an attorney, if I had to represent someone, I would much rather represent someone who complied with the order of the cop and got out of the car. I would much rather do that. And, when you get out of the car, close your car door behind you so the cop can't snoop into the car. But get out of the car. Do what the cop tells you to do. Let me, the attorney, or whoever your attorney is, obviously I'm not representing you, but let the attorney argue it in court. In your civil law matter or in your criminal law matter. Let the attorney argue it in court, because that's where legal arguments matter. That's where the judge is. And the judge is the one who decides what is and isn't a lawful act by the cop. What does and doesn't violate your Fourth Amendment rights. The judge decides that. Not you, not the cop, the judge. Let the judge do that in court where the judge is. Thanks for watching. Be safe out there. Don't listen to idiots. Don't get hurt by the police. Have a great day.